I will shine in as much as NDC party ni mo ayede no sanso na utwa weni ekopie mo ewo NPP party mu nso a eno nso ayede sanso na mpanimfo a ehwe oman no so no omo nso omo botom ayede na mpempren de panin bi allegedly panin bi edisika bi ahye no ho asasika no die enye yie mami nchira na mo akwa abaso nko emfa omra possible multimedia endie kwan so ene ni de kan we ni channel so YouTube ansa edansa ebe so se jebre na ye hwe video no mani nkwa wie so uhwe wi ano like wa comment wa subscribe wi ano share content no and to recommend channel no ama uni bi so enya ye videos ni bi ahe mpempria bi no ka se di amanebo a beto yapon so ene se NDC lawyer bi ababonten ede afutu sembi ede abre minority leader ato Forson say it is not too late say obeko back door and so obefa back door no wa pempenifo bi aka ne ho no mo de jantoa ade akoto nana adwanim esan say the anioma no say the anioma so e wo court no because third accuser no cry ekogina mu e wo court na say ye no cross examination abusia ototo papa so the anioma no ansha na yewra NDC minority leader ato force na akwa kopiemu e won sawam na lawyer yi so e kan sem bia obi bia ota court no e bi kra na wadwen enko so eno no e ye tape o de che Ghana fo nyina tisiu honorable ato forcing e wusia lawyer no tape o de ma Ghana fo na so de ma ato forcing de say court na oguso e di akone aba no onfa na ni nto fom na do be court a obehu say security e wo court o na say policemen e wo court no e do so no meaning say sada no e bia na wansan nechi anko fie e bia na sada no wansan nechi enya akonya ene ne wife anko di nkra wanya akonya anko nechi ene na busuafo anko akodi nkra ebusia nsem aloye e kan ye futu sem a ode ma ono ani nua be ma ato Forson ise bebre ne kan o mesraw kame ho ni na yemmom ne nkonko tie dia NDC lawyer e dia betuja na asamba akwa mekoso ebusa ne se wo yo pani a wo ene se wo som o manfo anase wo manfo ene se omosom na edisika esoma se ye bibi fa boa o man na e se wo disika no e hye wo ho na wo de ye nnuama ebeboa wo nko an ho anase e se wo hwe so na wo ye de nam so edisika no esoma wo no na e bo abaso ebusia yenko ne nkonko tie nsem ne munchemu ne wi a na efilifi ne a charge on comment section no asenya hopon insha yin na.
That's the question you must ask yourself. Who is in the dock? Is it Attorney General or is it the accused person? See, the thing about criminal trials I always tell people is that the day you receive your charge sheet, you receive it alone. See, the day you are called to come and write your statement, you'll say, you know, so that's why my famous lecturer once said, Professor Kumado, that the best lawyer is the one who doesn't allow his client to sleep in the police cell. So when you are called to accompany your client to write his statement, do everything possible in your power to make sure that your client does not sleep in police cells. Number 2, kill the case before it gets to trial. Do everything legally and within your power to ensure that the case does not come to trial. You understand? Because when it comes to trial, it is 50-50. Now you see,
balance of probability.
The accused person, you receive the charge sheet alone. See, the first day you go into court, you see the support and the morale, especially when you are a political figure. I always tell politicians.
The time goes on.
On the first day, everybody is there. Do you understand? Then you get to the middle. Then you begin to go day by day. Now, when you look at your back, I've been in this house before, so I'm telling you practical things. When you start going, when the trial starts, one day, sometimes you look at your back, you even see any human being at your back. Me, my former party chairman, EC Court, when he went the first time, I can count the number of supporters that were there. Then, when the trial continued, you can count the number of people that you see at your back. The day I'm coming, the day the judgment is read, that is when lawyers return to psychologists. You understand? Because at that time, in the US, they can say you can do a plea to vacate the decision. You can even do a motion on your feet for bail pending appeal. They will allow it. Some jurisdictions in the US say that once you have a right of appeal, you should not go into prison that day, you should be allowed to exhaust your appeal. So you're allowed to go home. It's white collar crime. You're allowed to go home and put. In fact, they even say go and put your house in order. In Ghana, you wear suit. Look, I've seen big guys come into court. They've gone for all-night prayers and everything. They have been told by their prophets and things. Look, they'll come sometimes. Me, I've been in prosecution. I've been in defense. They will put oil, anointing oil on their hands when they are coming. They will wipe some on their face. They will do everything. Then, but you know, as prosecutors, this is a tip. When you come to court on a judgment day and you see that the police presence at the gate is more than 2 or 3, know that you are not going home. That one I can tell you on authority. I repeat. So how do if you have know? That one is not of your business. I'm saying that I said if you normally when you go to court, I say normally when you go to court every day, and those who know when you go to court every day, and on the day of judgment, you know the number of security people at the post. You can count them. Normally there are about 2 or 3 at this gate. Another maybe 1 or 2. When you see extra police presence on that day, you understand, and then you walk the corridor and you see extra police CI decide they can't play close, know that you go home that day. That's one. Number 2, on the day of judgment, we the lawyers will psych you up that everything will be fine. You come with your supporters and everything. When the judge reads and say on count 1 I convict, on count 2 I convict, on count then your lawyer starts to write his what he calls mitigation. You understand? Plea of mitigation. At that time, the judge has convicted you, so you change, and automatically your sitting position will also change. Your sitting position where you sit will change. This is called you are now a convict, so you see that automatically the security people will come and stand behind you. You understand? And then your lawyer will have to do a plea. Yes, no, here, cancel, mitigation. That time, you are still in shock. Then your lawyer will say all the bluffo. Maybe the sentence and everything has already been written. That's that the judge will record him. But maybe the sentence has already been written in the listing. When it is done, then you'll be led. That is when you came in suit. You will not change your dress. Not the same door you came through. You park. I've seen big people who came in their car, drove themselves. Their car was parked for days at the court until somebody else came for it. Because freedom is such that sometimes I think that you should hasten slowly with certain things. You understand? So I will still say, you understand, that in my opinion, the best way out of this particular matter, you understand, I know a lot of things have gone on, and that's why sometimes when you attack, whether you like it or not, the person who is in the chair, until the person is no longer in the chair, he's in the chair. It's like president. Until the 7th of January, the president of this country is President Akufo-Addo. He's the only one who can sign pardons. He's the only one who can sign certain things. So there's the need for you to maintain some cordial relations. You understand? I think that looking at the persons involved, you understand, I don't think it's too late for the deal preferred by Big C, right? To be taken off the table. You understand? I think that a lot has been said. You understand? But
what do you mean taken off the table?
Off the table. No. I'm saying that I don't think it is off the table.
All right.
And Kabi, let me just conclude. I don't think that it is off the table. I believe that those who have ears and those who have a voice should take that Big C deal and try and use it. Look, in this country, Nana Kudedu Ajimarolis was on trial as a sign of reconciliation. The president, then outgoing president, when the election results had been announced, decided to order the Attorney General to enter a nolle prosequa and let the matter die. We have the president has powers, you understand, to allow for certain things to be done. I think that there's still a political solution to this issue.
That sounds conciliatory.
No, I'm telling you, see, Obi. I know, so you see, I always speak differently. You know, I always speak differently because I've experienced that tells me life. there are things that are just not worth the risk. You understand? They are just not worth the risk. So, because if you do this hard line thing, at the end of the day, I'm saying that look, the day things are you are alone. All I'll say is that me as a lawyer, my only interest is that at the end of the day, my client does not go to prison. And so I'm saying that there is a big C deal worth 2 million euros. I think if it can be brought to 2.3 euros, I've repeated this. I said that look, the government of Ghana is more interested in the recovery of money than the sentencing of anybody to prison. It doesn't near to the benefit of anybody. I appeal to the president. You understand that all executive power is exercised in his name. It is not too late. You understand? This can lower police crime, because at the end of the day, I keep telling people that causing financial loss to the state is not about somebody stealing. Nobody has said, I want everybody to understand, nobody has said that Dr. Forson has stolen any money. What the state is saying is that his action has led to the loss of state funds. Yes. You understand? That he should have exercised better and discretion in the use of his powers as a deputy minister. Yes. So that point must always be, you see, people believe that, or some people have the misconception that the state is accusing Dr. Forson of stealing 2.3 million euros. That is not it. You understand? And so if that is not it, and somebody is offering, you understand, that amount as a panacea to the issue, and he is at that point as minority leader, I don't think it is impossible for a deal to be had. Yes, you may not like Godfred Dame, and that is not about, you see, the issue, that is where, as long as we don't take personal positions, do you understand? Your interest is not about whether you like somebody or not. You can always call him the names after, but at the end of the day, your interest is to what? Get your client off. And that should be the primary interest of your in criminal trials, which is something that I teach on a weekly basis. An accused person or persons are brought before court. A charge sheet is prepared. And then we have what we call particulars of the charge, which is to say that on this date, within this jurisdiction, you may even add at a particular time. So, for example, if you were accused of robbery and you were seen in somebody's house with a gun at, let's say, 2 a.m., you may even add the time. You understand? Because you are entitled at law to know the nature and specifics of the charges that are being laid against you, the accused person. So the charge sheet will read, on this and this date, if there's a time in it, you know, you are accused of doing this, that, which breaches a particular law, you understand? And there's a punishment prescribed for that particular act. So that act is prohibited by a certain law, and there's a punishment prescribed for it. That is the standard that our criminal jurisprudence prescribes before something will be deemed to be a crime. So you are in court and you have been charged with specific offenses. So the prosecution, which is the Republic, will now present evidence. So one, they must first pass the test of having a good a charge sheet that is acceptable to the court, enough particulars in there for you to respond to those charges, which include facts. Now, then the duty on them is they must produce evidence. They will lead the evidence, can be through persons, through documents, whatever. What they have to do is to bring enough evidence before the court for the court to come to a conclusion that you have a responsibility to now open a defense. You are not guilty. Remember that you are presumed innocent. So as we speak, all the 3 accused persons are innocent until they have been pronounced guilty by the court. But the first stage for the prosecution is when they close their case, they must have presented enough evidence whereby the court will say, for you, I have enough evidence to justify why you must come to the court and explain to the court why you did this or you did that or you did this or you did that. It's not that you are guilty. It's just that maybe the court is satisfied that, let's say, for example, robbery. You were seen at the precincts of my house at around 12 midnight carrying maybe a gun. You understand? Now, that is enough for the court to say that you must now come and explain why you were around the precincts of my house with a gun at 2 a.m. on this date. It's not to say you are guilty. Maybe you are a watchdog committee member. Do you understand? So then you will come and explain that, yes, I admit I was around your house at 12 midnight on the 6th day of January 2020. You understand? And I was parading and this day, and I had to enter your house when I heard noises. You understand? However, I was there because I'm a member of the neighborhood watch committee, and we have been mandated to carry these arms to protect the neighborhood. That will qualify, or that may, in the eyes of the judge, qualify as a reasonable excuse why you were in my house, you had jammed my wall when you heard noises, and you heard that you heard a in the area, so you were patrolling. You understand? So that is the nature of the arrangement in a criminal court process. Now, the question I keep asking myself is the tape and everything else. You see, the procedural issues would have been. So let's say we have ancillary issues like fair trial. Every accused person has a right to what we call a fair trial. So has your right been abused? Maybe in taking your statement, the police took the statement at 12 midnight without the presence of your lawyer. Those are procedural issues that can give rise to the court saying that the charges that have been preferred against you, you understand, were preferred against you in breach of your rights. And so on account of that, it is throwing the case out. Maybe you are arrested and the arrest was unlawful. Your human rights you were beaten up. You understand, to elicit a confession from you, among others. Those ones go to what we call fair trial. So those ones can be grounds upon which your lawyers would have come to say, no, A, B, C, and D that has been done is in breach of fair trial principles. But in a case where you are not seeking to throw away the charge sheet, that's one. You were seeking to maybe stop the trial on the grounds of fair trial and all that. All those things have been thrown out. My worry as an observer, as a lecturer and all that, is that there are specific charges that you have been charged with. Do you understand? So anybody who, and you see, even in the submission of no case, they were fortunate, and some judges don't do that. This particular judge, which is what I think should be the standard, was able to tell each accused person what is required in terms of what she's looking for by way of answers. So if you read the submission of no case, she tells A1, you, at the close of the case of the prosecution, this is what they have been able to establish against you. I need you to explain to me this. So for Dr. Forson, for example, his own is about the authorization. Because the judge at the end of the submission of no case said that the court is satisfied that the ambulances were not fit for purpose. So there's no debate anymore unless you go to an upper court and overturn that finding of fact. I hope you understand.
Were the ambulances at all?
Whatever, yeah. So that one there, it is. I won't speculate. What I say is that this is at least what I know. That the judge says whatever was imported as the first tranche was not fit for purpose.
Based on the evidence.
Based on the evidence before her. That is a finding of fact. He says all the parties agree. That's the way. All the parties. So accused person and this, you all agree that what was imported was not fit for purpose. For A1, we need you to explain to us under what authority you allow that ambulance to be imported, to be paid for. So if you decide to spend your time on other things, that one is entirely your business. You understand? Because the court and you see, the court will not allow you to one day come and say that you had evidence and you were not allowed to bring the evidence. We have what we call all evidence. All evidence is admissible. All relevant evidence is admissible. So what you deem to be relevant to you, you bring it. No court will say that if you want to call 1,000 witnesses, so long as they are not coming to repeat the same thing, you'll be allowed to call. Because tomorrow you will go and say somewhere that you had evidence and the court did not permit you to. So if you want to spend your 6 hours, this judge also is very strict about case management conference. There are judges who are very liberal with the case. They can allow you to go this. If she says 6 hours, it's 6 hours. Unless you can convince her why. So you all agree. At the case management conference, all parties agree. I'll need 6 hours for witness 1. I'll need 6 hours for witness 2. So if you spend your 6 hours on the tape, on the Jakpa tape, you are entitled to it. You cannot come tomorrow and say that you were given the opportunity. And so if you, and for Jakpa, she also gave the specific things she's expecting him to speak to. So all the accused persons have been given a cue in the, in the submission of no case as to what they must address the court on